They're perfect for him. Bobby, Bobby, they were perfect for you. I highly suggest it. I don't just suggest it. I'm saying go full bore on this. Abso-freaking-lutely. Absolutely. I love this idea of so much. So we have, this is now a death penalty case. Okay? We're going to hear the charges, but we are not getting into what she did. Don't worry. It doesn't, the charges are bad enough to hear. They just are. But we don't hear any details. None. Don't worry. That's not why we're watching this clip. We're watching this clip because of this woman declining the plea deal. And there's especially one part that makes me realize why she declined the plea deal, which is super stupid, but I know why. Let's see if you guys do too. Here we go.
This involves case number 2026-CR0024-LHB, charging Jessica Marie Motes with malice, murder, felony murder, cruelty to children in the first degree, aggravated battery, concealing the death of another. I will advise the court, because of what representations we had made to the court concerning the possibility of a guilty plea in this case, that as of Friday afternoon, that was the information that we had, but that changed over the weekend, and so I've understood that she's not willing to enter a guilty plea this morning. So it's very important that I put on the record that she has been given an opportunity to enter a plea of guilty before the filing of any notice of intent to seek the death penalty and to receive a sentence with life without the possibility of parole. She's here, she's in court, she's with counsel, Mr. Hammond Law, Mr. Andy Dowdy, and so I'm reiterating on the record that before this proceeding concludes, if she remains willing to do that this morning, if she is willing to or becomes willing to do that this morning, I'm still ready to present that. However, in the meantime, we had scheduled through the cooperation of the court what was to be the first proceeding in a death penalty case, and I do have a notice of intent to seek the death penalty. And it is as follows, comes now to the state of Georgia by through the District Attorney's Office for the Northeastern Judicial Circuit, hereby filing the state of Georgia's notice of intent to seek the death penalty in the above styled manner pursuant to 17-10-31B2, the offense of murder committed while the defendant was engaged in the commission of an aggravated battery, as alleged in count 4 of this indictment in this case, and pursuant to 17-10-31B7, the offense of murder was outrageously and wantonly vile and inhumane in that it involved torture. I need to make a correction here. And so I'll have that correction be made. Inhumane in that it involved torture, depravity of mind. And if we need to make that change before we formally file it, and an aggravated battery to the victim. So I did notice that typo just now, so we'll make that change and provide copies to the court. So we do intend to seek the death penalty case pursuant to what we will be filing today.
Yeah, but it's North Georgia, Bren, so the accents aren't thick. They're there, but they're not thick. But Bobby, I was just, when you had your ad, I was just saying, I agree. You should go for those two, both women, both of them. But they are, because they're too far north to have the accent. Now, again, that's almost the worst we're going to hear. we're going to hear one more tiny little bit where you're going to, yep, yes, she did. I don't know if it's children or child, but that's the worst you're going to hear this whole clip, what you just heard.
And so now, of course, we have scheduled it for a first proceeding as well. Where's my book?
In just a minute, Mr. Dara. Ms. Moats, go ahead and raise your right hand. Do you swear affirm the testimony you give here to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, and Ms. Moats, you're seated next to your attorneys, Mr. Law and Mr. Dowdy, is that correct?
Yes, ma'am.
And you heard Mr. Dara state that an offer was made in regards to closing the case with a guilty plea today, resulting in a sentence of life without parole. And in the event that the offer was not accepted this morning, so now we've reached that time, that the state would be offering or would be filing their notice of intention to seek the death penalty. Did you hear all of that?
Yes, ma'am.
And you're choosing to reject the offer knowing that the state is going to be filing a notice of intent to present, or a notice of intent to seek the death penalty?
Yes, ma'am.
And I'm sorry, I didn't hear you.
Yes, ma'am.
And have you had enough time to discuss that with your attorneys in making that decision? Understanding it's a very large one.
Yes, ma'am.
All right, and so, Mr. Dara, based upon the announcement that you're going to be filing a notice of intent to seek the death penalty, this circuit has a procedure in which another judge may be selected to preside over the death penalty case. And we have copies of that order and that procedure that we'll provide to both the state and defense, as well as, out of an abundance of caution, a copy of the unified appeal procedure. Emily, if you want to give those out.
And the unified appeal procedure was said should be followed beginning on January 15, 2026. So I assume that what you're handing out is the very newest one.
It was printed this morning from the Georgia Supreme Court website with the addition that there were modifications made as of January 15th of 2026. And so in a first proceeding, normally the court would go through a number of different matters. I'm just going to hit a few of them. And then, quite frankly, once the selection of the judge for the death penalty case is assigned, allow them to handle another first proceeding. But given the fact that I may not be presiding over.
So I think this is Hall County Courtroom 403, I think. So it's probably going to stay in Hall County. If it stays in Hall County, then I have a chance of getting it, this whole trial. If it doesn't stay in Hall County, I don't know if I'll get it. Because, like, Judge Reeves stopped streaming. Not every single judge in Georgia streams. So if I get this case, maybe I'll put it in members only. So you choose whether you want to watch it or not. But maybe if it doesn't get too graphic in the verdict, I will play the verdict.
For the death penalty case, allow whichever judge assigned the case to handle their own first proceeding.
Yes, ma'am.
I do want to put a few things on the record. Mr. Law and Mr. Dowdy, you're both retained, is that correct?
Yes.
And you've been provided a copy of the unified appeal procedure updated January 15th of 2026.
Yes, Judge.
And is it your intent to remain as counsel after the notice of intent to seek the death penalty is filed?
Judge, all I can say is we're currently counsel. We are not withdrawing as counsel. That's all I can say at this time.
And Mr. Law, you've already filed for discovery under 1716-1, correct?
Yes, ma'am.
And may I state that we have provided discovery to counsel, and counsel has represented it to me, and I believe it to be true, has thoroughly reviewed the discovery provided, included primarily the GBI investigation report involved in this case.
Judge, the only thing I would add to that is that they've been forthcoming with what they could turn over to me. And since you may not be the judge on the death penalty case, I just am pointing out there could be some delay because we do not have a copy of the autopsy, and we're told by the district attorney's office it may not be ready for anywhere from 4, 5, or 6 months.
Yeah, yes. Don't worry, sir. The autopsy will come quicker. It just will. With this case, and, you know, don't worry, they'll get it to you quicker. But that's the part that made me figure out, oh, that's why she didn't want the plea deal. The prosecutors, the judge, one of them just said, and you have thoroughly gone over discovery with her. You know, and you have this, all the discovery. The attorneys were like, yeah, we did. She wants to die. There's absolutely no other reason. She's gambling, you know, with the death penalty. She can't say she's innocent. You just heard what they said about discovery. They have her dead center. You know what I mean? So, yeah, that's why she didn't take the plea deal. It has to be why. She's just going to do, you know, suicide by death penalty. And we can't put ourselves in her shoes to wonder, you know, what we would do. Because we would never be in her situation. This isn't one of these cases where we can understand what she's thinking. Nope, we can't. So now they have to, they're not going to get the autopsy. Yeah, they did. Drunken Smurf just had a 15-year-old cold case return get busted wide open. Arrest was made and murder charges were filed. What state is that? Drunken?
And I imagine that will precipitate experts and that kind of thing. And I just want the court to know that in discussing it with anybody about scheduling it.
And, sorry, go ahead, Mr. Dare.
And I will further make what efforts I can to have that expedited. I'm not sure of the time frame myself, but
It's not going to be 6 months, though. Don't worry. Monica has a 105 stream streak on Twitch. Yeah, Monica.
hopefully we can get that expedited in a shorter period of time.
And so, Mr. Dare, do you want anything else addressed today based upon your announcement that you'll need to provide copies of your notice to myself as well as to Judge Deal, the chief judge of the circuit, so that he can schedule an opportunity to select the new judge assigned to this death penalty matter, and that I'll allow that judge to have their own first proceeding, so they know their own schedule. I can't issue any scheduling orders at this point based upon the fact that I may not be the one presiding over the case.
Under those circumstances, it's probably best to hold the additional first proceeding before the assigned judge and before the arraignment, et cetera, as provided for in the Unified Appeal Procedure.
And Mr. Law, do you feel that you need, or Mr. Dowdy, do you feel you need any other matters addressed today? Just we'll use today as a status hearing only.
No, Your Honor.
All right, then that will conclude the matter in the Moats case. And Mr. Dara, we'll look forward to seeing your notice of intent to seek the death penalty.
Yes, ma'am.
All right.
Filing that today. Thank you.
You're excused.
I'm not even going to try to figure out what I would do. What she's thinking. Nope. I don't know if it was her child. I don't know if it was someone else's child. I can't see Drunken. I absolutely will try to get it. I absolutely will, but I can't replay TV news on my channel because that's copyrighted. I'll get a copyright strike against me. Oof. That would be bad. I know that Josh has a real juicy one he wanted me to play too. All right, let's get to some consequences. Now, All right, let's do this one. It sounds like the wife has not been charged, just the husband. And I feel, okay, what the husband did was very bad. What she did was badder. Badder, I think. I don't know. She wasn't in danger of killing anybody. He was. But she prevented anyone. Right. I don't know. Let's just see.
So in other words, an additional 1,500.
Yep. Yes, Your Honor.
Mr. Carlsless, I think you already offered some explanation. You want to be heard?
So we have two cases here. The first one is this guy. The second one is the husband and wife duo criminals, but she's not charged.
Heard now, you'll get the last word before I make a decision here on the bond.
Yes, I mean, I clearly, I have the woman who posted my bond at my last court appearance, at my initial appearance, is in the courtroom now, I believe, and brought me to my court appearance on Friday, also believing that it was on Friday. I think that we were both misinformed. I know that ultimately, I think it comes down to me to know which date my court is or whatever, but I clearly wouldn't forfeit her $1,000 bond, nor would she, and bring me here if I knew that that was my court date. I'm trying to not have another issue like this and have another court date. I'd like to get this all resolved today, if possible, and put this all miles behind me, if I can, Your Honor. I really would not want to deal with another court date. I'm not trying to. I know they said they put together a deal for me. I really am here nor there whether I get a deal or not. I just assume to plead guilty to all of my charges.
Mr. Carlslist, I've heard 4 variations of the same thing. Now you can stop talking. I'm going to tell you what we can do today and what we can't do. One thing we for sure have to do. Yeah, one thing we for sure have to do is keep a good record. And you're talking kind of quick, and we have to make sure we have a clear record here. Mr. Carlslist,
What the heck is a Cahories? I don't understand what you guys are talking about in chat.
I'm not comfortable. This is these are serious allegations. I don't think there's a felony involved here, but it's a CM case. But these are serious and significant accusations. I'm not the assigned branch. I am not going to. I'm not going to preside over any resolution this afternoon. It's possible that the assigned branch will, Mr. Carlslist, that's branch 3, and the court's judicial assistant will relay your request to have the matter, attempt to have the matter resolved today. But that's, I'm going to consider the state's request for cash. I'm going to consider your explanation. And that's about all I'm going to do today, Mr. Carlslist. I'm also not going to, he seemed to suggest the possibility that we take up whether there's actually going to be a forfeiture judgment with respect to that cash that's on hand. And that's already noticed up. And even though the surety is here, I'm not dealing with that either. And the court does have considerable concerns, Mr. Carlslist, notwithstanding your record. There's on the whole, a significant concern that if there's not an additional amount of cash here, a sizable amount, that the court system won't maintain access to you. I tracked most of the explanation, but at the end of the day, and I think you alluded to this, it's on you to make sure you know when you have to be in court and to be here. And it took law enforcement to have to arrest you and bring you here. And it's a situation where, given that other history described by Attorney Flint, I think some more cash is required. The court is going to require an additional $1,000 cash to be posted. That's in addition to what's on deposit already. The court believing that this is the minimum to ensure future appearances and especially.
I have that. If I had to get $1,000 cash to get me out of jail, I could right now. But There's no way I would. Look, if I get arrested, I keep saying this. I'm staying. I'm staying in jail. I'm not coming back out in this cruel, cold world.
Special conditions, established.
Okay. I would agree with that, with the posting the thought.
Okay, we'll just do that. And so the special conditions from the last bond hearing will continue. And so, Mr. Carl's list, I had to mute you because you started talking over me. And like I said, we have to make a good record here, especially where liberty
Come on, mute me. Mute me, Judge.
stakes are, oh, liberty interests are at stake is what I meant to say. Let's see here. The court's, this court's judicial assistant checking on the availability of branch 3. So stand by. Team's response to the inquiry, unable to provide an answer right now.
You can
This
replay
court's
all my old
response, who's
videos.
unable, just for clarity. Response to that inquiry, Judge Daring just took the bench. Lori needs an okay. Well, and
My
they have a
son-
civil block.
My son a prison guard? I could bribe that boy with a cookie.
No criminal clerk scheduled. Sure what I'm supposed to do with that. But anyway, Mr. Carl's list, you have the court's requiring that extra cash. And so what I'm going to do is put you on Judge Daring's calendar when it's understood or known that the court's available. Oh, like tomorrow at 1:30, apparently that court's available. There's no statutory victim here, correct, Attorney Flint? Let's see, no. 1:30 on March 3rd, 2026. We'll just call those further proceedings. Anything else, Attorney Flint?
No, Judge.
And Madam Clerk?
Nothing, Your Honor.
Okay, recess, thank you. Okay, Mr. Neely, did you, well, wait, did you go over a document called the plea questionnaire and waiver of rights form with your lawyer?
Yes, I did. Your
Okay,
Honor.
did you just sign that document?
Yes, I did. Your
Did
Honor.
you understand everything in the form?
Yes, Your Honor.
Okay. Let me just take a look at it here. So it says, sir, that you're 28, that you have 7 years of school. Do you have any difficulty with the English language?
No, Your Honor.
Okay, are you prescribed any medications?
No, Your Honor.
Thank you, Bobby.
These constitutional
Thank you.
rights on this form, your right to a trial, your right to remain silent, your right to testify, to use subpoenas, to a jury trial, your confrontation right, and your right to make the state prove your guilt beyond a reasonable doubt. Did you discuss all of those rights in detail at length with Attorney Nelson?
Yes, I have, Your Honor.
Do you understand that if we resolve this matter this afternoon, those rights are given up forever when it comes to this particular charge that you're entering a plea to?
Yes, Your Honor.
And if you plead no contest to this charge of second degree recklessly endangering safety as a repeater, and if I accept that plea, I will find you guilty and there will be a felony criminal conviction that enters as a result. Do you understand that?
Yes, Your Honor.
As a convicted felon, you can't possess a firearm. If you do, you could be charged with another felony. If you're convicted of that felony, you could be imprisoned on that conviction as well. Do you understand that?
Yes, I do, Your Honor.
You can't vote in any election, not until your civil rights are fully restored. Do you understand that?
Yes, Your Honor.
Is that your signature on the second page, sir?
Yes, Your Honor. It is.
Okay.
Transition to what? A man?
The state would have to prove two things, Mr. Neely, at a
I'll be
trial.
Kevin.
First, that you endangered the safety of another human being, and that you endangered the safety of another human being by criminally reckless conduct. Those are the two things that the prosecutor would have to prove. She would have to prove them beyond a reasonable doubt. That is the highest burden in our system of laws, and all 12 jurors at a jury trial would have to agree that that she was able to do that. If that doesn't happen, you're not convicted. Do you understand?
Yes, Your Honor.
Attorney Nelson, are you satisfied that Mr. Neely is in a position to enter a plea to this charge in a knowing, free, voluntary, and intelligent fashion?
Yes.
He understands the nature of that allegation, the maximum penalties, his constitutional rights,
All right, we're about to hear the charge, guys, and what happened this night. What the balls on his wife, though, man. Let me tell you, she has not been charged. Just remember that.
And the warning to him about giving up the rights.
Yes,
He appreciates the consequences of his plea and the conviction. And is there a sufficient factual basis before the court for a plea to that charge?
there is.
So, Mr. Neely, what's your plea to the charge of second degree recklessly endangering safety as a repeater?
No contest, Your Honor.
The court receives that no contest plea, and upon that plea, the court will find the defendant guilty, adjudge that he is convicted, and direct entry of judgment accordingly. That repeater modifier, there's support for that where in the criminal complaint, Attorney Nelson?
Yes.
Okay.
That sounds right, Mel. Yes.
Point that out to me, Attorney Gramberg.
Should be the very last paragraph, Judge. Aggravated fleeing police conviction and receive, possess, or sell stolen property with an aggravating fleeing, both felonies, disposition entered in February 24, 2025.
Sounds like an out-of-state conviction, but if nobody wants to stay on this part of the record, we'll move on. So there's a sufficient factual basis. Mr. Neely understands that's something else the state would have to prove. Somebody stop me if any of this is inaccurate. He appreciates the consequences of his plea and the conviction, and there's a sufficient factual basis, again, before the court for a plea to that charge. As to the first and third counts, is there a motion to dispose of those, Attorney Granberg?
State moves to dismiss and read in.
Anything else on that, Attorney Nelson?
Just 1 second, Judge. I just want to be clear for the record that outstanding matters in Illinois from 2025, there's not a conviction in those cases. However, there was a conviction for a felony case in Illinois in 2023. So I do think that the repeater is appropriate.
Okay.
And then I have no objection to the state.
Very well, that motion's granted. What are you recommending, Attorney Granberg?
Thank you, Judge. This is a stipulated recommendation to the court for 3 years of imprisonment consisting of a 1.5 years initial confinement and a 1.5 years extended supervision concurrent to any other sentence in being.
That's crazy that they're asking for 3 years of prison for this. Prison. He should get some jail time, but they just asked for 3 years of prison for this. I'm not saying she's wrong. I'm just saying that that's crazy. That's harsh for what we're used to. This is Wisconsin.
This fleeing case is one of the more, I would say, aggravating fleeing cases that I have charged in a while. The trooper was on Highway 94, gets behind the defendant's vehicle and attempts a traffic stop because there's no vehicle associated with the license plate. He then activates his lights and sirens, and a Jeep that is later found to be driven by his wife gets in the behind the Dodge and then slams on its brakes to essentially not allow the trooper to conduct a traffic stop. That Jeep then straddles both lanes, tries to make sure that the trooper can't get to this Dodge, but is ultimately unsuccessful. The Dodge then takes off in speeds over 100 miles per hour, going from Jefferson County to Waukesha County. There are tire deflation devices that are used several times. At some point, both of the back rear tires are blown out of Mr. Neely's vehicle. He is the one that's in the Dodge Ram. And he eventually has to be pitted. Then he puts his hands out the window, and after the fleeing, he is cooperative with law enforcement and is taken into custody by gunpoint. What aggravates this, in addition to the charge itself and the conduct with the fleeing and the driving, is that he does have that prior criminal conviction for aggravated fleeing out of Illinois. I guess if the other one is still pending, that I didn't know that, but there is at least one conviction for the same conduct. So I do think a prison sentence is more than appropriate, and I would ask the court to adopt the recommendation.
So, so the wife, that's true love, guys. That's true love. She risked her Jeep, probably all the little ducks in the Jeep, risked those. I mean, listen, if you're not willing to put yourself in between me and the police chasing me, then you don't really love me.
Okay, Attorney Nelson.
Judge, we do think the recommendation is appropriate. Mr. Neely has taken responsibility for his actions today. I watched the video, the behavior with the driving. Mr. Neely openly admits it was dangerous. As far as the other driver on the road that night, nobody's been charged to my knowledge. I don't know if there's any actual evidence at this point, or any case involving the other driver. But Mr. Neely is making the court aware he's taking responsibility for his actions. When he is stopped, he is very cooperative with law enforcement. I can tell the court, I think a lot of this bad judgment and poor behavior on Mr. Neely's part is conditioning from his early life experiences. I don't think he had the cognitive ability to kind of make a distinction between what was prudent at the time and what was instinctual to him. And that's how he ends up in front of the court today. As the court might have heard, he was already facing some fleeing issues in Illinois and have been put in drug treatment court there. He had been doing really well in the drug treatment court program in Illinois. I've spoken with his attorney in Illinois. He was making great strides. I've seen the paperwork from that program, but for this new case, I think he would have been successful. Since he's been incarcerated, he has been making good use of his time. He's been attending NA. He's completed Smart Recovery and also participated in Celebrate Recovery. I think that the time recommendation in front of the court meets the sentencing goals, and I do ask that the court adopt it.
Mr. Neely, sir, is there anything you want to say to the court before the court sentences you? You're not required to, but it's your right. So if you have something you want to say, I'd like to hear it, please.
I would just say I would appreciate the courts recognizing the efforts that I have been putting in over the past few years.
Oh, shut up. Just shut up. You just ruined everything. Hi, CJ. I want to hear from the wife. Shouldn't she be blocking him from the judge right now?
But in drug court, and even though I've been advised that I'm going to prison in Illinois also because of the severity of the case, I'm being kicked out of drug court. Even knowing that, I'm still choosing to continue my recovery, to be able to adapt properly to society and just be better for my family.
I recall Mr. Neely hearing, I don't remember which hearing it was, but that you have children.
Yes, sir.
And is it? Well, you asked me to recognize something, and I will recognize several things here, Mr. Neely, that are.
Okay, at this point, to me, it sounds like the judge is like, okay, we're gonna see this judge with almost no real evidence, grant a protection order in a second. It's crazy. Then this is an actual real crime. He could have killed a lot of people. And the judge is like, yeah, like, oh, I don't know how to describe it. It's like the boys club, like, oh, you were just playing around, like it's not a big deal.
I think are positive. I mean, I'll talk about what you did here in a second, and then we'll be done talking about it. But you have taken responsibility. It sounds like you have some insight after the incident as to how dangerous your behavior was and how you endangered other people. And it sounds like you are prepared and willing to do the hard work that's going to go along with reclaiming yourself.
How does it sound like that to you, Judge? Because he said that he was going to continue treatment? Because he said that? Because he said those words? What evidence do you have of that statement, Judge? Anything. Just give me anything.
And getting sober and staying sober. And that's important. And, when Attorney Nelson makes reference to conditioning and acting impulsively or reflexively, that's a tough nut to crack. I don't know what your early experiences were like. My mind is going to a place that involves you in a really not pleasant upbringing, and it's going to
There was no evidence of that, Judge. Not zero evidence of that. Zero. So you're that's a mitigating factor for you?
It's going to take a lot of hard work and some special people and some special resources in your life to get at that, Mr. Neely.
Brent.
I don't think, I certainly don't think all is lost, but there's going to be a lot of demands on you, Mr. Neely, and I sure do hope that, I don't have much control over your day-to-day, week-to-week experiences in the prison system. I sure hope that you're resilient to anything that's going to frustrate your efforts and your hard work at sobriety. I know one thing, or I'm somewhat sure of one thing, that you're not going to have access or easy access to any drugs of choice.
Again,
Yeah.
there's zero evidence of no drugs in jail, Judge. He's going to prison, Oh, sugar Jude, thank you. Live chat. Yeah, but he's got plenty of drugs available. Plenty.
That's important. And, I have to do something here that's reflective of, I think, a basic public sentiment that this is something we have to deter. This was really dangerous behavior. And again, you recognize that, and that's important. In taking responsibility, we have the convictions. I am going to adopt the agreement. I think it furthers the sentencing goal of measured punishment and deterrence and protection of the public. It considers his character to the extent, his criminal justice background, to the extent that I've been informed of that. And, rehabilitative goals or efforts are very important too, and I'll make him eligible for both forms of programming. And we'll have conditions of extended supervision that further that interest. So it's going to be a 3-year term of imprisonment consisting of 18 months initial confinement, 18 months extended supervision, concurrent to any other sentence in being per the agreement. He has to comply with DNA sample requirements, pay the surcharge, again, finding him eligible for both forms of programming. That's not really the final word when it comes to that, but that's the box I'm checking, or the boxes I'm checking on the worksheet. Conditions of extended supervision, AODA assessment and follow through with recommended treatment per agent, any other assessment, treatment, or counseling per agent. Mr. Neely must attempt to obtain, maintain employment and or educational programming per agent. All of the financial obligations are DOC collects, and those include statutory costs, the DNA surcharge, $250 for a felony conviction, and that's it. The time credit, Attorney Nelson?
I believe there's 174 days, Judge.
174 days, Attorney Granberg?
Stipulated?
174 days credit.
That's crazy. He was in jail for 174 days already for driving 100 miles an hour. That's not crazy to you guys? Like, we don't even see someone dealing meth spend that much time in jail.
And Mr. Neely, you do have the right to appeal this case. Make sure you understand that, right? Make sure you know what the deadline is. Good luck to you, sir.
Thank you, Your Honor.
Anything else, Attorney Nelson?
No, Judge, thank you.
And Attorney Gramberg?
Nope.
Madam
I should wear a robe.
Nothing, Your
Yes.
Honor.
Recess.
I should wear. No, I should wear Australian. I should wear one of those robes with a little bow tie with a little. Or I could go UK and I could get one of those wigs. One of those. No, I can't. It's too hot. It's way too hot for that wig. Nope. We're going to stick with this judge, all right? This judge is now dealing with a creep. A creep. But,
I don't like to assess credibility without seeing somebody as they talk. So,
what he's saying there, I don't want to assess credibility without seeing someone who, when they talk, the defendant is on the phone with no camera. So the judge is not letting him speak. No testimony from him.
Who's the gentleman seated to your left, ma'am?
That's my husband, Coy Lathrop.
Okay. And I did get your recent correspondence. I'm gathering that when you filed the petition, you reviewed the petition, you understand what your burden is, what the burden of proof is. And so it seems that there's some desire here to proceed with some expediency or efficiency. So call this witness that you want the court to hear from, ma'am. Is that this Jesse Scott individual?
Correct.
Ma'am, raise your right hand. Madam Clerk, swear the
Don't we all, Bobby? Don't we all?
Do you solemnly swear that the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, ma'am, go ahead with your questions. Well, actually, Ms. Scott, just state your full name, please.
Jesse Rachel Scott.
Common spelling for Scott, S-C-O-T-T.
Yes, sir.
And how do you know the petitioner?
Her daughters and my daughter have played softball together for a couple of years.
That checks
Okay.
out.
All right.
Spend a lot of time together.
Okay. So, Melissa, go ahead with your questions.
Melissa has a time delay.
I guess I don't have questions, I guess. Really, I don't know how this works. I apologize.
Okay, yeah, you're the petitioner. You have the burden of proof. And so usually what's common is folks ask people questions to establish their case or press their case. And so I can't just simply rely on what's on paper so far. So either you're going to testify or somebody's going to testify. That's what I anticipated.
Okay. So, Jess, what did you see occur with Reese in the hallway?
So specifically with Reese, a bunch of the parents were standing in the hallway. We had a team dinner that took place in the room that actually we were standing outside of, or maybe it was one over. But we were standing there talking and just like without going into all of the things that happened before leading up to that, I was standing there across from Coy, Melissa's husband, and he was facing the opposite direction, and their daughter Reese was standing behind him. And I was just across from them, maybe 5 feet away. And while I was standing there, I saw Ryan, there was music playing in the hallway, and I saw Ryan go over by Reese, and he started dancing in front of her and was trying to get her to dance. And it was, given the events or the things that had taken place leading up to that point, I was really uncomfortable with, I would be uncomfortable with him doing that anyway. She's like 9 or 10 years old, and tiny, and he's very tall. But I was uncomfortable with that immediately. And so I just grabbed her and I pulled her over towards me, to keep her out of and away from that. And Coy was right there, but however, he was facing the other direction. So he didn't see what happened. And, I just had to get her away from that.
Next question.
Could you talk about things that you saw occur in the hallway prior to that?
Can you say that one more
That
time?
maybe
It
would
kind of cut out.
enlighten why the could you give some specific occurrences that happened that made you feel uncomfortable prior to that?
Well, it kind of been, by that point, it had kind of different things, little things that added up going on for a few hours. And Ryan and I hadn't really talked much before. We were at the water park because the tournament was in Chula Vista Hotel. Well, the tournament was in the Dells and we were staying at Chula Vista. And he saw my tattoos and we got to talking, and that's fine. I hadn't really talked to him before. He was, could tell he'd been drinking, and he was kind of a very serious guy, which, I was in the Army and used to talking to very serious guys. And there was a few other coaches and parents that were kind of around, and I went over to talk to them because I was kind of feeling awkward talking to Ryan. Not really for any specific reason at that point. And I went over to Dave, who is the coach, and I was talking to him. And at that point, like, Ryan walked up and he like walked onto one side of me, but he like reached around and like flipped my hair or my ear or something on this side as if he was on the other side, which made me really uncomfortable. That this man that I barely know is like also just touching me. And again, like I said, I was in the Army. I'm not any stranger to drunk guys doing dumb stuff. But as that kind of went on, he did it another time at the hotel, which was also kind of strange. It was not touching my hair, but he like walked by and like touched my shoulders, and I don't know, Dave, the coach, saw that. But as the night went on.
So for the record, he was dancing around a 10-year-old. Like, there was a bunch of parents there, a bunch of kids there, and he was dancing in front of one of them. And then he touched her hair. And then I think she said he also touched her shoulder at a different point. That's where we're at right now.
I witnessed, well, one of the things, and I don't remember specifically if this was before Reese or after Reese, but the thing that this was after Reese, but the thing that made me the most uncomfortable was I walked into the hallway and there was a group of girls, or in the stairwell actually, there was a group of girls looking out the window of the hotel, and they were excited about something they saw. I think somebody walking by doing something weird. I mean, they're 10 years old. And they were gathered at the window, and Melissa and I actually, because we were kind of made uncomfortable by Ryan throughout the day, we were constantly kind of checking on the whereabouts of the girls. And I was standing there talking to them, and it's kind of hard without like a diagram, but we were kind of at the landing of the stairwell with the girls on this side and Ryan on this side. And one of the girls turned to walk away, and Ryan stuck his arm out and stopped her. And at that point, I stepped in between them because that made me extremely, extremely uncomfortable. And I got in between them and then told him that was wrong to be doing, and for how many reasons why. And he got really defensive, and we were kind of arguing at this point because he was basically telling me to shut up and go away, but without those words, he was saying, okay, bye. And I was just trying to tell him why it's inappropriate for him to be having any interaction with these girls other than the normal thing of a softball parent just being in the vicinity, or just regular talking or whatever. But putting his arm out and stopping her was, again, it's just kind of throughout the days, similar events. That just kind of was my last straw with it. And I tried to be I tried to be calm with him and try to explain why, and he was getting angry and defensive, and that was it for me.
So with a bunch of parents and children around, he blocked the stairs from one of the kids from leaving that area for a second.
That's all I have for Jess.
Thank you. Ma'am, is there, give me that print job, please, Chris. Mr. Stankey, do you have any questions for this witness? Thank you.
Were you drinking?
Everybody was. I was drinking, but I wouldn't
That's
say I was
him
drunk.
right there talking.
Part of that was because of the things going on. I didn't want to be that way.
Have you ever
Next question.
talked to me prior?
Have I ever what?
Have you ever talked to me prior to this event or previous events?
Only in passing. I mean, I gather the administrative documents and everything for the team, but other than that.
So, okay, so Melissa is the mother of one of the girls or two of the girls. Two of the girls on the team. Softball, I think, or something like that. I don't remember. And Jessica is the parent of another girl on the team. And this guy, can't remember his name, doesn't matter. He's the father of one of the girls on the team. A different girl. Three different girls. Three different people.
No.
So there's no other conflicts?
No.
Okay. No more questions, Your Honor.
All right. And then Melissa, any follow-up to those questions and answers?
To that, no. There's a couple more things I'd like to be said, though.
Okay. Okay. Ms. Scott, you can leave the meeting if you want. And then Melissa, are you calling any other witnesses?
I am not. No.
Are you calling yourself as a
Besides
witness?
myself.
Okay, raise your right hand. Madam Clerk.
Do you solemnly swear that the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, ma'am, provide your testimony in support of your petition.
So I would like to add that there was another incident with our older daughter. She's 11, Hadley. She's in the report, but he also followed me into my room and picked her up off the edge of the bed and held her and like cradled her next to him. She immediately looked terrified, and I asked him to put
There he crossed the line, right there. There he did cross the line.
her down, which he did after a few seconds of me saying enough, like put her down. So that's another incident. He also followed some of the players up and down the hallway besides just the stairwell, making them feel uncomfortable. There's a CPS report that I put in. Also, there is a police report through the Dells that I was not allowed to retrieve because it's an ongoing investigation that I would like you to know. I know the case number's on the report for the restraining order, but I just want you to know, like, I was unable to retrieve that from further information because it's an ongoing investigation.
Even though you're
My
the statutory
girls
victim, yeah, they might want to consult with their counsel. Are you seeking protection on behalf of Hadley in addition to Reese, or just Reese?
So if I could get Hadley added, when I did the report, I'm not familiar with court and how that goes. I thought that, you know, as long as I had her included in the report, that it included her, but then was later told once we were filing that I'd have to do a whole separate report. I don't know how that works, I guess.
Any other testimony, ma'am?
But it's just overall, nope. I guess besides that, my kids are scared of him. At this point, they were very comfortable with him up until that weekend.
Mr. Stockey, do you have any questions for the petitioner?
Second. Melissa, have your daughters been picked up by me prior, asking me to pick them up prior? Been fun?
Not that I'm aware of. I've never seen you cradle my kids like that.
I believe they asked him to pick them up prior. I believe that happened. I do, because I mean, think about little girls, and dads at softball or whatever sport. I mean, they treat dads like a jungle gym. Kids do. Kids treat men like jungle gyms. They do. But younger, I don't know.
Any other questions, sir?
Do you recall sending my wife a text stating myself and Willow were allowed in your room?
That was earlier in the day, prior to all these events, nor were you welcomed into my room when you followed me in my room. Nor was your daughter in the premises at that point. She was down in a room sleeping with another one of the team parents.
And
because
if you've ever been to one of these team events, they all get a block of hotel rooms. And all the girls and the parents are just in and out of everybody's room all day, all night. They're just the doors are just always open. And everybody's going in and out of everybody's room. That's not anything unusual.
You didn't have a room at the hotel.
Nothing further, Your Honor.
All right. Now, Melissa, he asked you questions. Now, just in light of those questions and your answers, do you have any additional testimony?
I don't at this time.
Okay. Now, the court finds without any difficulty whatsoever that the petitioner has met her reasonable grounds burden.
The court finds without any difficulty whatsoever that this guy crossed all these lines. The guy who was speeding and could have killed everybody. Oh, you're just playing around. I'm sure you didn't mean it. I'm sure that you are going to go and get drug help.
We'll just a reminder about how harassment is defined by the legislature: striking, shoving, kicking, or otherwise subjecting a person to physical contact, engaging in an act that would constitute some sort of abuse. That's not what's going on here. But I found the petitioner's testimony credible. I'm not going to take testimony from Mr. Stanke. He's not available with video means. And so, and by extension of the record that was made in connection with the request to protect Reese, there's an equal and sufficient basis to sign an injunction with respect to, what's the other daughter's name? Hadley? Harper?
Hadley?
Haley? What is it?
Hadley? Hadley.
So the court is going to sign 2 injunctions. And you're not requesting any orders regarding firearms, ma'am, is that correct?
No, it asked in the report if he had them. The only thing I know is that he talked about hunting and stuff. I didn't know what to do in the report at that point.
The question is simple, ma'am. Ma'am, the question is simple. Are you requesting any orders concerning firearms for him?
I mean, if he has them, I wish he didn't have them. So yes.
There's only one married man I wouldn't go into his room, and that would be my own husband if I had one.
Some essential findings here. The petitioner, on behalf of her daughters, filed a petition alleging harassment under 813.125. What she's described qualifies or fits the description under state statute. The court has personal and subject matter jurisdiction. There's proper service, and there are reasonable grounds to believe that the respondent has engaged in harassment as defined. However, there is not clear and convincing evidence that the respondent may use a firearm to cause physical harm to another or to endanger public safety. I don't have that sort of record before me. So the court makes the following orders. The respondent is to cease and avoid the harassment of these two girls. He's to avoid their residence or any premises temporarily occupied by them. He's to avoid contact that harasses or intimidates the petitioner or the two girls. Contact will be defined on the order. He's to avoid contacting the petitioner or the person's protected or causing any other person to make contact with them other than a person's attorney or a law enforcement officer unless there's consent in writing for contact. Do you have anything else for today, ma'am?
Nope, that is all.
Cancel the firearm surrender hearing. The court's not going to make such an order given the record. Anything else, Madam Clerk?
Are both girls' names on the injunction, Your Honor? Or are there two separate injunctions?
Are you talking about the proposed orders?
Yes, I'm sorry.
I'm only showing the one for Reese.
Okay.
By her initials, yeah.
I'll prep a new one. Thank you.
You'll do another one, Chris?
Another one, yeah.
Thank you. What's your other daughter's middle initial, please, ma'am?
Jay?
Anything else, Madam Clerk?
You are a
Recess.
princess.
Thank you.
Yes. I don't know, Granny. You're right, but after watching all these court cases every day, all day long, men did this to themselves.
When will those orders be available at your office, Madam Clerk?
Just did.
I would mail them unless you wanted to pick them up. They'll be ready later today.
All right.
All right. We're going to do this one.
This is Creekmore. 73 DO2 2504 F689 Connie Creekmore and 2601 F64 show Martha Showers appears. What are we doing today?
Judge, we kindly request for continuance on both cases. Discovery is being provided, has not yet, but should be hopefully today on the first case. And we are wanting to just track the fact finding for the probation violation of this case and request continuances on both.
I think I'm ready to proceed on the fact finding hearing. So,
okay.
Yep. So, yeah, I don't like it.
How often do you hear that? Judge, I want a continuance. No. Nope. We're going to do this today. Okay, Bren.
Wait. So, I like consequences pretty quick. So, D, come on up.
Okay.
Yep. We'll just do it up here. Yeah, absolutely. Yep. All right, we're back on record with Connie Creekmore. Martha Showers appears, state appears by Adam James. What are we doing?
Judge, my client is willing to admit to the allegations of the petition to revoke probation. Specifically, the defendant consumed methamphetamine as evidenced by positive drug screens,
Okay.
as well as the defendant was unsuccessfully discharged from the alcohol and drug program on or about January 9th, 2026.
Okay.
Request that a dispositional hearing be set out to align with her pending theft case.
Denied.
She is going to a 30-day IOP treatment, inpatient treatment at Jasper Creek that she's going to go on the 7th or 8th of this month. So we're really hoping to get her.
Yeah. That probably didn't meet my time frame, what I want to do. So, yep.
She just asked to put sentences off for 1 month. It's like, no, we're not continuing it. We're not putting sentences off. Nope.
All right. So is she's going to admit open then? Is that my understanding
Yes,
to those
Your
two
Honor.
things? Okay. All right, Connie, raise your right hand. Do you affirm under pains and penalties of perjury testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Yes. State your name for the record. All right, Connie, you can put your hand down. You understand you were set for hearing today on a petition to revoke probation, correct?
Yes.
I put you on probation back on June 23rd. State of Indiana alleges that you violated probation. What you're admitting to is that you consumed methamphetamine, and they allege in several different dates: August 8th of 2025, August 20th of 2025, September 16th of 2025, October 7th of 2025, October 21st of 2025, December 15th of 2025, and January 9th of 2026. And that you were discharged from the alcohol and drug program on about January 9th of 2026. Now, it's my understanding you wish to admit that. Is that correct?
And Judge, if I may clarify the record, there was another test were positive on February 12th.
Perfect. Thank you.
Judge,
All right.
Judge, you missed one of the dirty drops from my client, Judge. You missed one just a couple days ago, Judge.
So you're willing to admit that. Is that correct? We are set for hearing today. Despite your admirable efforts by counsel, she wanted to continue this, but I'm not having any of that because this has been continued enough, and I believe that consequences need to happen as close as due process allows to the events in order for it to have the maximum effect. You understand that? When your kid steals a cookie and breaks a cookie jar, do you spank them then, or you wait 10 weeks and spank them 10 weeks down the road? Yeah, that's the theory, basically. There needs to be immediate repercussions for those, but we still have to have due process, and I believe I've given you enough time to figure this out. I'm not mad at your lawyer. I'm not mad at you for wanting to kick the can down the road. I would want to do that if I was in your shoes or in her shoes. You know, that's what good lawyers do, but I'm not going to have any of that. So your choice is to stay or have the hearing, which we were set for, and I would decide what to do, or you can admit and this, and we'll proceed to sentencing today. You understand that?
Yes.
Yes? Okay. All right. So I could give you some, none, or all of 319 days executed. You understand that? All right. If I force, threaten, or coerce you to do this, all right, this is what you wish to do after consulting with your attorney. You wish to admit this, correct? All right. All right, then I'll find you violated probation. So we'll proceed to sentence by consuming methamphetamine and by failing to complete the ADA program. All right. So why are you still consuming? Yeah, I understand that. Okay. And who are you hanging out with that this is allowed to going on? Are you living by yourself, or who are you living with?
But I take care of my parents.
How old are your parents?
Of course, they don't agree with none of it.
Yeah, no, I'm not. I'd be shocked if they did.
It was my neighbor, but they've moved, so it's nobody's.
When did they move? Like, if you tested positive February 12th.
They just moved 3 days ago.
Wait, what?
I'm still.
No one is like on ankle monitors in Australia? Is that what you mean? That you guys just don't have ankle monitors? You either go to jail or you don't go to jail.
Mm-hmm. Always like to go back.
Feel like
he keeps asking me to pay for his paw pictures.
More than just them,
Sure there is.
Here, so that's why I feel like.
And I do.
This is the first time I've ever figured that it's time I need help.
But we're here not because of we're here because of a theft case. We're here because you stole stuff. That's why we're here. That's why you're on probation, not because of methamphetamine, because you went to Walmart and stole things. And it's not the first time you've stolen, because that's what made this a level 6 felony,
Well,
right?
actually, I didn't steal this time, sir. I got proof that I paid for the items.
You pled
The one
guilty to
that's-
theft.
No, on the probation case, yes.
That's what I'm talking about, probation. I'm not talking about your new
Okay.
case.
Okay,
That you're presumed innocent. I'm talking about your probation case. You're on possession for theft. You're on possession of theft. You're on probation for theft.
yes.
All right. And this was a level 6 felony theft because you got a prior conviction for theft. And now you've got a pending theft case, but I'm not considering that. All right. What else do you want to tell me before I pronounce sentence? You can ask questions of your client. Yes.
Well, sorry.
Martha, if you wish.
I got a hold of Jasper Creek.
Mhm.
I've been talking to them quite often. I've been going to IOP still with Lacey McCorkle and Lindsay, and Josh Green's my doctor through there, as well as Dr. Lincoln. Have a wonderful group
Mhm.
of doctors with MHP. And we all agreed, as well as my probation officer, we're all in together, and you know that would be a wonderful thing for me to do, is going to Jasper Grove.
Mhm.
It's a medical facility as well as IOP.
Are you going to pay for that?
My insurance.
Your
does take
insurance can
care
cover
of
it? Okay.
And signing a release with Lindsay. I already agreed to do that with my probation officer as well as IOP.
You don't have to agree to it. I've
No,
ordered
I
you
want-
to do that. So, you know, I mean, that's part of your conditions of probation. You sign a release of
I did this all on my own, Judge. All on my own after you ordered me to do it.
information pertaining to treatment, right? Why didn't you complete the ADA program?
I had a urinary tract infection and I couldn't get a screen that day. And that's why she dismissed me.
What about
Well,
the
it seems
other
like it wasn't
17?
taken anyway because you had all these positive screens. Your ADA assessment was done when?
My ADA was on 9,
September?
yes, and
And they
I
made
gave-
recommendations, right?
I gave some clean ones. I did give
What was the recommendation of your assessment?
that I go to IOP.
And did
Which
you do that?
I finished moving on and got my certificate of completion with that, like 2 weeks ago with Scarlett. And then, I was still doing the IOP, and I still am doing the IOP as well still.
Okay.
Even though they discharged me through probation, I still didn't discharge myself. I still, went to them because I know I have a problem and I need to take care of it.
Okay.
I'm not giving them
All right.
my health.
Any other questions from anything else, Marty, you want
Just
to
some
bring to my attention?
clarification, how often do you talk to Lindsay with MHP?
With MHP,
Yeah.
I've talked to Lindsay. We have video appointments as well as on Tuesdays and Thursdays.
So every Tuesday, Thursday, you speak
Yes.
with her virtually?
Yes.
And when do you see Lacey McCorkle?
I see her like every 3 weeks plus every Tuesdays and Thursdays. That's in class that I go
In person?
Yes.
That you see her?
Yes, as well as Lindsay too.
Now, with Jasper Creek, when do you anticipate going to Jasper?
They'll have bed ready for me. They said on the 7th.
7th
If not, it would definitely be on the 8th. they
7th
said.
or 8th of March?
Yes, this one,
Okay.
which is next week.
What does that program entail? Oh, sorry.
I don't understand.
If you're checking in on the 7th or 8th, what happens there? Are you there
I'm
for?
hospitalized for the first 2 weeks due to my illness and medication, so that way they can evaluate me. I have no contact with nobody at that time.
Guys, there is
Not even
like
home.
2 inches of cleavage.
After that,
She
they
has
put me
breasts.
through due process. What they
Everything
need
is
me
covered.
do
To
after
get
they
to a
evaluate
nipple,
me while under hospitalization.
there's just no way. She could
Did
bend all the
Lacey
way
and
over.
Lindsay suggest you
It's okay.
do this program?
I did, but yes, they did too.
Okay.
I mean, I went to them and told
And ultimately, how long does this program last? How long?
it's 30 days, or if not longer.
Okay.
Whatever they feel is needed for the process, because it's even an aftercare with IOP, and they're all like on a group together. So,
And
because they have an intense IOP as well.
And they're gonna look at not only the fact that you have a problem with methamphetamine, but they will.
What
help with-
became the problem of my the things, because there's always a reason.
And are you, okay, talk about, yes, okay, so you've been diagnosed with what?
I've been diagnosed with PTSD, trauma,
And you're,
HIV.
so you're HIV positive and they're gonna help with all the medications, all that. Okay, Judge, I have no further questions.
So where is, what's this treatment center called again?
It's Jasper Grove.
Jasper Grove.
Sorry, yes. Jasper.
And you live there?
Yes.
Like to see a handout, Judge. She does have a handout for her.
I'm looking online too, yeah, I'll take a look at it. When did you first contact Jasper Grove?
2 weeks ago.
All right, I'm gonna send you 180 days. I'll execute the Shelby County Criminal Justice Center. You can report to them afterwards. If they were able to get you in on 2 weeks' notice, I'm sure they can get you in afterwards. My concern is that you had many offenses, positive drug screens. You're on for theft, and there's just got to be consequences. So remanded custody of the sheriff to serve your sentence forthwith. If you don't like my sentence, you can appeal it. Do so by filing notice of appeal within 30 days of today's date. If you cannot afford an attorney for the appeal, the court can appoint one for you. I'm going to terminate probation upon completion. So your probation will be terminated. So yes, it's 90 days actual. Yeah. And then when you get out and you can go to Jasper Creek, you'll be perfectly clean and sober. And then I think you got a better chance of making that stick. Mm-hmm. Yep. So as far as your other case, I've granted the motion to continue. So I'll reset that for April 13th will be your final pretrial at 8:30 a.m. Your jury trial is going to be April 21st at 8:30 a.m. In the meantime, if you get something worked out between now and then, I'm happy to bring you back over and we can address that thing. So, all right, Connie, you're man of the custody sheriff. Thank you.
I think she looks fine too. I don't see
Yeah,
anything.
everything paid within 6 months after release.
All right, we got another one now. We got a
This
per
is a
se
DOC
guy.
commitment.
This is more of like a casual chat court.
We were requiring that. Yes, that's fine. No. Can I take this off?
Yeah. I mean, if you don't want that to go, if you have a family member here, you want to send that.
Diane says she'll take it.
She's here, yes.
Okay, that's fine. Hey, we're here on Clarence Danner, 73 DO2 2506 CM 377. Mr. Danner's filed several motions. I think motion to dismiss. I think, is that right? So I guess we'll start on that. Do you have any argument or case law you want to support, Mr. Danner, on that?
On the motion to dismiss, I wasn't, it was the same. She was the same one that was sitting on the case to begin with, and there wasn't no prosecuting attorney there. I mean, it's kind of, she was already sitting there. It was, what was that day for?
How are your legs, Kay? Are your legs feeling better?
What was that hearing for?
I don't know, Clarence. I wasn't there. I don't know.
That hearing was on the June 18th, right?
If you're asking on the resisting, that was June 18th, correct?
Okay, and, there was a petition for all the information to do with what was going on with that, or what happened on that day. And I've received some things, but I ain't ever received notification what that day was actually for. I got the order where the one June 18th hearing was for his felony offense. The allegation of CM occurred during or shortly after the hearing of the felony case had been dismissed. Court grants said request, but I've never received any documentation of that whatsoever.
Okay. Do you have anything else you wish to bring up?
I was just wondering if you could go back and what did it say on like the criminal case or whatever on the docket? What was supposed to be said that day, or what it was for that day?
Well, the state of Indiana might have to get into that a tiny bit on their burden of proof in this resisting case, because the allegation is, as my understanding, you were at a hearing, you were using language that was not appropriate to court, and the magistrate ordered you removed, and during the course of that removal, you resisted. So the state will have to give a little bit of background as to why you were down there, and that the officers were lawfully engaged in their duties as a law enforcement officer. But other than that, I don't really know that it matters, Clarence, you know. So you can bring that up if you wish. It's during the case of your defense, if you wish to present that. But
Eileen, I mostly got this because his name is Clarence.
my staff said it looks like it was an initial hearing. So apparently that's what it was. So she looked
Initial hearing for
a criminal case. Yes. I don't know. I wasn't there, Clarence.
well, shouldn't there be papers that I could get documentation on that?
You can have a copy of the CCS, which you have that. I mean, that's out there on the web. I mean, that's at my case. You can have that.
I know, but the only thing that I've got from that is contempt of court.
Well, during the initial hearing, you should have, well, do me just print off. Yeah, we'll just print off all the paperwork associated with that case. I don't care.
I'm just wanting to know what.
I understand. Well, I'll give you a copy of that file. So,
All right, I appreciate that.
all right.
377, one whole thing.
Yeah. Mm-hmm. Mm-hmm. All right. Anything else on your motion to dismiss?
The conflict of interest with that,
I'm going to hear the resisting. I think that that's appropriate for me to hear it. So I'm going to hear the resisting case instead of Magistrate Kinsley.
But Judge, he just told you that you shouldn't hear that case. You have to listen to him. He wants a different judge.
So she's going to hear the other one still, but I'm going to hear the resisting.
okay.
You have anything else?
On my
I didn't
other
understand it.
motions with they have to be with you reviewing the dismissal, you chose not to. I mean,
It's dismissed, Clarence. There's nothing to review, bud. It's dismissed. You're talking about the F6 case, the felony case? It got dismissed. There's
No,
nothing to review.
no, review the dismissal as you being old and so forth.
Oh, I'm not muted. He wants two things. He wants this judge removed, and he wants this judge to do a judicial review of the magistrate who held him in contempt of court.
The judicial review on the magistrate.
I don't have to review that, Clarence. The magistrates are used to be in the old days, you had to have a judge kind of sign off on a magistrate's decisions. You don't have to do that anymore.
Yeah, but for the record, I'm respecting request clarification of the court conducting no vote review.
That's why I explained to you just now. I don't have to do that anymore. Used to be you had to. You don't have to do that anymore. They changed the law.
Peg Leg was a Viber. He came in here. He was a lawyer. So he had great insight. He helped us a lot.
When did blockage?
Probably about 7 or 8 years ago.
How come I wasn't ever granted anything for a jury trial, even though from the beginning of me taking over this, I wasn't able to get a jury trial?
You were advised if you want a jury trial, you must demand it in writing at least 10 days before your first bench trial setting. So I don't know that you did that.
Oof. All right, Red, I'm going to do my best, but you walked into a pro se who filed a bunch of motions. I don't know what the original crime was. I don't. But he went in front of a magistrate. He started swearing at the magistrate. The magistrate threw him out of court. The bailiffs came to try to get him out of court, and he resisted arrest. So he got contempt of court for that. So yeah, he had a felony that was dismissed, but now he has a whole bunch of misdemeanors that he has to deal with, and he filed a bunch of motions in these misdemeanor cases. All right, and so the judge today, right now, is just trying to get through his motions. That's it. He's not moving any of the cases further. He's just trying to clear away some of the motions that are in front of him, because there's so many and they're so twisted into all of the different cases. And there's two judges. Well, there's a magistrate and a judge, so that makes it even more a little confusing. But this is the judge, all right? The other one is a magistrate, so this judge has, more bite than the other judge. So this judge can do more. So he's able to handle the motions for whatever case he wants to at this point. But what he's saying is, I think for the contempt of court, that I'm gonna let you stay with the magistrate on that, because he did it to the magistrate. And I don't think I get the magistrate. I don't think so. So I don't think I'm going to get that. But for the resisting, I am going to get that. There's going to be a trial for the resisting. He wants a trial. Right now he's complaining that he didn't get a chance at a jury trial, which he wouldn't for misdemeanors. He could have for the felony, but he didn't file the right paperwork in time. I hope that helps.
On the writings, it used to say I had one for the resisting arrest.
Not in the misdemeanor case, you wouldn't. Misdemeanor on the felony, when you had that felony case, you would have had it.
If you look in the court docket on all the records, it was taken off one day. It wasn't.
Yeah, let me look here.
What's really, really stupid is the felony case, the underlying case to all these other cases that he got was dismissed. If he would have just behaved, he would just be done with court right now, because the case was dismissed. But no, he got all these other charges now.
Because I even have a recording where I taped.
Hold on, let me look, okay, bud? I've got to have the chance to respond.
If you noticed, there's no one else in the gallery, because the judge waited till the end for this one, because he knew what it was going to be.
It appears on June 25th of 2025, you had your initial hearing. And they set bond the amount of $5,000, 10% cash, and set a pretrial for August 5th.
Okay, I got a question for you, Red Fox 88, but I don't know if it's offensive, because I'm American and we don't use this word. We don't use this term. So first off, are you easily offended? Because I have an Australian word I want to ask you about without offending you. But if you're easily offended, then I just won't.
August 5th, a pretrial conference. And a pretrial got reset for September 30th. On August 14th, you were in custody. Was counsel Ronnie Miller, who appeared in person, state by Adam James. Parties agreed to remote proceedings. The court modifies the pretrial set September 30th at 1:15 p.m. to a bench trial omnibus the same date and time. So on August 14th, your first bench trial was set September 30th at 1:15 p.m.
No, Bren, you're wrong. I can prove that it's Australian because they have a boomerang hanging right on the wall. Uh-huh.
Hold on. And now it says, your attorney requests a continuance of the bench trial on September 30th. That was filed on September 25th.
I love asking Australians if they're easily offended because it's funny to me, and none of them are.
And the first motion I see of anything is October 14th, you filed motion to reinstate jury trial.
I told him from the beginning that I wanted a jury trial on every case.
Well, that's not what was filed, so.
But the record does indicate that I did have a jury trial at one time. I know I got a picture of that where it says it.
Not in this case, you didn't. Not in this misdemeanor case, you did not. I'm sorry? It referenced a jury trial in the CCS, but that was talking about the level 6 felony case because we had a pretrial, combined pretrial. So you do not have a jury trial setting in this, and nor are you going to get one. So we're going to keep it a bench trial.
All right, I'm going to ask you, Red. Fox 88. Are you or are you not a bogan?
I mean, I object to that.
That's fine. I understand. It's part of the record. You can bring that up.
I told my lawyer from the beginning to have a jury trial. From the beginning, I never wanted a bench trial ever.
Okay. Well, he didn't demand it. And
I mean, because he was inadequate. He wasn't following through my
you can bring that up on appeal, Clarence. So we've moved on beyond.
territorial jurisdiction or anything like that. He didn't file anything. I told him to file it first.
Okay. Do you have anything else you wish to address on your motion to dismiss or any other pretrial motions that you filed?
You're right. You're right, Great Granny. You're right. I think Red is a man, though. I don't know why. If she comes at me that she's a she, in my head it will always stay male.
I'd like to. Was I ever on probation or anything for anything?
I'm not answering questions. I'm not under oath.
No, I was just wondering if I was ever on probation for anything.
I don't know, Clarence. You would be the best person to know if you were on probation.
Ain't been in trouble for 10 years. At least. I mean, if I have my attorney on tape saying that I asked him from the beginning that I wanted a jury trial.
We're beyond the jury trial for the purposes of this case, Clarence. You can bring that up if there is an appeal. Okay. But you can't get to the appeal until we've tried the case. So if you're quitted, it doesn't matter.
Or they don't certain perspective.
Okay. Anything else?
Please confirm.
Okay.
Because I'm gonna get that and what the 18th was about right now, right?
Yeah, I'm giving you a copy of everything that was filed in that case.
And can I get the orders for, what, like the findings on, like what came after on,
Not even her little pinky toe.
charges like
The
this?
rest of that you can get the clerk's office and pay like everybody else does, Clarence. I'm not going to be your secretary getting you all that
I
stuff.
was just asking. I didn't know where to obtain, I'm sorry.
All that is at the clerk's office. All those, if you want copies of the court's file, it's at the clerk's office. Okay.
Bro,
And for the record, Clarence is representing himself. He has been. I've already found, or Jenny already found he wanted to represent himself. You still wish to represent yourself. Is that correct, Clarence? Okay. All right. All right. State have in response to his February 2nd motion to dismiss for lack of jurisdiction and authority.
I don't think there's no Indiana code cited to do that. I think there's sufficient evidence that
Speak into the microphone. He never speaks into the microphone, ever, this prosecutor. Anyway, okay, he just said Jenny. So the magistrate he might be talking about could be Jennifer Monroe, maybe. I don't know if she's a magistrate, but if it is Jennifer Monroe, I will get that case too. It just means like hillbilly. So, I mean, it's not that bad.
All right. As to the form, court finds that the motion to dismiss has not complied with the rules. More importantly, on the substance of it, to the extent that he's asking to dismiss the case because the level 6 case was dismissed, which I think you call the jurisdictional anchor. The court denies the motion to dismiss based upon that. As to paragraph 2, enforcement occurred without an adjudicated jurisdictional basis. The court denies the motion to dismiss based upon that. As to paragraph 3, government created impossibility bars enforcement. The court denies the motion to dismiss based upon that. As to 4, the resisting and assault charges are derivative. The court denies the motion to dismiss based upon that. And as to number 5, continued restraint after known factual collapse exceeded authority. The court denies the motion to dismiss that. All right, so I'm going to set this matter for a bench trial. It's already set April 7th in Magistrate Kinsley's court. Adam, that's not a good day for you, is my understanding.
I'll be gone. And so I talked to Magistrate Kinsley on general availability on the battery that she's going to hear. I did talk to Clarence about it. I'm going to advance that one to March 19th. And then, so, yeah, as far as the resistance, I talked to Clarence about that as well. If I either get a continued or advance for that day.
Are you going to do that March 19th? And is that magistrate available in the morning for that?
She is, due to the child support with the things that are going to be off that day. So tentatively, I'm going to do that at 9 a.m.
Well, you want to just knock it out at 1 o'clock in the afternoon on mine then?
Yeah, that's fine.
Is that all right with you? Just that way you got one day and they'll both be over with.
Trust Bren or don't trust Bren. I think, listen, 80% of the time, I think I would trust you and go head first into what you're saying. I feel like this time, though, I shouldn't. I don't know why. Something is telling me that that's a bad idea. So, you know what? I'm not going to do that. I want to, though, just because.
The court's mine to be at 1 o'clock. So,
yeah, that's fine.
will that work? And we'll just, everything's done. Okay?
Oh, yeah.
Then we'll know. Yep. Okay. All right. So I'll set it for trial March 19th. Clarence, again, I'll caution you because you are representing yourself. You are bound by the same rules as everybody else. You gave me some citations that were completely false.
No,
not that they were false.
It means hillbilly. It means like hillbilly.
They did exist, but they didn't say what you purported them to say. If you're going to give me citations, the cases better be on point. You understand that?
Oh, I understand. I'm trying to do the best that I can.
Well, I understand that, Clarence, and I've offered to hire lawyers for you. You don't want them, you have that right, but I have to hold you under the laws, the same standards as a lawyer. You're going to be subject to hearsay objections. You're going to be subject to the rules of evidence and all that. The rules of evidence are online. You need to familiarize yourself.
I got files.
You need to familiarize yourself with all that. All right, we'll see you March 19th at 1 p.m. in my court. I'll give you a reminder. All right, here you go. All right, thank you.
He gets to walk out though. He didn't get contempt of court with this.
That's for which one are you?
I know why.
That's this.
Because you just don't mess with this judge. He will just put you in jail, period. So, guys, thank you so much for coming out today. Hold on. Had checkup today, positive, tumor shrunk to the point it's barely there. I'll give you blood. I will give you blood. I will just sit right beside you. You can take it right from the vein. There's a little slight alcohol in it right now, but you'll be fine. By the time I fly the whole way over there won't be any alcohol in it. Unless I drink on the plane, which I will. But I won't tell the doctors that. Guys, Bren, you're such a champ. Thanks for coming. It's my new name for Bren. He's a champ. I'm going to call him that every day now. Yeah. Oh my gosh. What if that was true? Linus, I give you some of my blood, you end up just like me. That's right. A little alcohol never hurt no one. Guys, thanks for coming out. I appreciate it. I'll see you. Oh, it's the weekend now. It's Friday. You just got to get through the work day and then it's the weekend. I'll see you all tomorrow morning. Behave. Be nice. Do something nice for someone you don't even know today. Good. Bren's offended. Yes. Yes, let's go. Let's go. I bet I could offend you. I bet I could. But I would never, ever, ever. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, she's